Thank you very much. It's a real honor and a privilege for delighted and most grateful to colleagues at Amity University and especially in the law school. I have many wonderful colleagues who I've been collaborating with for the last 2 years now in research and publishing at the Amity Law School. And so it's a real honor and a privilege, as I say, to be invited to do this. So I'm most grateful to you for asking me. What I'm going to talk about, and I'm not sure distribute this to the people that are going to be joining. I've distributed a document that I've Warren's title and transfer of property in Australia, which may seem like not the most interesting, but what I want to do is really just talk about real property law in Australia. So, but before I do that, before I start, as I say, I hope that people might have access to that document if they're joining this before I move to talking about the main topic, I just want to say a couple of things. Firstly, I know that you'd hoped that I'd be giving some sort of a comparative talk. My talk won't be that comparative, although I think broadly speaking, the sorts of things that I'll be talking about, real property law, broadly speaking, would be similar, at least in the underlying structure, if I can put it that way, of real property law, would be similar in India as it is in Australia. But what I'll be talking about today is a particular development or manifestation of real property law as that has evolved and developed in Australia. Right. So that was the first point I wanted to make. It won't be necessarily comparative, but I hope that what I say will have people will notice the similarities between the Australian and the Indian real property systems as I'm speaking. The second thing that I wanted to just by way of introduction say is that I'll be giving a broad overview. I mean, obviously, it's not going to be particularly helpful to your students for me to go into a lot of detail as to how Australian real property law operates. People that have background reading in the area, and if I tried to go into detail, it would just become unnecessarily complex. So what I really want to do is give a broad overview of real property law, land law in Australia, but not really descend into any of the detail of the concepts and the principles that I'll be talking about. And I think that hopefully will be more of greater interest to your students and to your colleagues than if I was to talk about a lot of detail and a lot of cases and statutes and so forth. I don't think that would be particularly helpful. So I think that it's better for me to give a broad overview of the way that real property law operates in Australia. I think that'll be helpful and hopefully of some interest as well. And the final thing that I want to say by way of introduction is just simply this. I'm not sure how long what I'm going to say will take. The difficulty is, I know from previous experience when, over the years there have been various occasions on which I've had to record a lecture for my students because for whatever reason, it was a holiday or I was going to be traveling and I couldn't be there on the day of a class. What I'd do is I'd go in and I'd record a lecture ahead of time. And what I always found, and I don't know how many people would find that this is the same thing for them, but what I always found is when I was talking to an empty room, I always seemed to get through the material a lot faster. So whereas, if I'd give an hour or an hour and a half lecture to my students and I had a full lecture theater, it would last an hour and a half. I had the right amount of material to last that long. I was giving it to an empty room and just a recording, it seemed like it went, in about 30 minutes, so an hour sort of seemed to be. I think that the problem is that when you're speaking to the computer or your laptop or to an empty room, I think the difficulty is that you're not really reading the response that you're getting from your audience. So you don't really know if they're following what you're saying or not. And I think that when you've got an audience right there, you can see how they're reacting. And so you slow down or you might emphasize things or you might repeat things so that you're sure that people have it. And that I think is lost. And so although we're obviously, as you are here in Australia, we are, getting fully up to speed with doing all of our teaching online, I think that there is still just a slight disadvantage when people have to teach because you really don't get that connection with the people that you're speaking to. So it's difficult to work out exactly how it's being received. And that's why I think it tends to go faster. So those are just introductory points, which really are of no bearing on anything other than just to let you know this is what I'm planning to do. And I don't know how long it'll take. And I think that what I'll do is I'll say everything I've got to say. And then I'm happy to open it up for questions. And then obviously, if some things, I haven't been clear about some of the things that I've said, or I went over things too quickly, then I can go back to deal with questions at the end. So if that's acceptable to you, then I'll proceed. And like I said, I'll go through everything I've got. Thank you very much. So the first thing that I want to do is I want to just point out in my general overview that I sent around that document, I had an introduction, and I say there that unlike in India, and I have to say that I'm clearly not an expert in Indian property law, but I do know enough to know that there is a Transfer of Property Act of 1882, and that more or less both real and personal property tend to be dealt with under that one piece of legislation. Unlike in India, where the transfer of property is dealt with under one piece of legislation, in Australia, and indeed in Canada and the United States and the United Kingdom and New Zealand, the transfer of property is divided into real property or land law and personal property, or chattels or movables, as they would refer to it in a civil law system. So what I'm not going to be doing today is talking about the transfer of property in relation to personal property or chattels or movables. I'm going to be talking about real property law. So that's the first point that I wanted to make about the Australian law of real property, is that it is distinguishable from and distinct from personal property. And personal property is an area of law that has all of its own complexities and subtleties and nuances. And so that in a place like Australia, in a place like Canada, in a place like the United States, you will find very much that the way we teach property in all of those jurisdictions is that there are specialists in real property law, and so they teach real property law, and that's their area of expertise. And there are specialists in personal property law, and that's what they teach, and they're specialists in that area. So that's the main distinction that I wanted to draw between personal and real property, and then to say, obviously, that the rest of what I'll say now pertains to real property in Australia. The first main thing that I want to talk about, if you think about real property law, you have to go through a couple of steps to get the full picture. And the first step that you need to start with is the idea of, well, what are the proprietary relationships or interests that a person can have in relation to land? In other words, when we say that somebody is the owner of land in Australia, what is it that we mean by that? And that is what I would call sort of the building block concepts that you need to understand before you can then move on to understand how it is that you transfer property from one person to another. You need to understand what it is that's being transferred before you can get to the point of talking about the fact that, well, how is it that we actually affect the transfer? So that's where I'm going to begin. I'm going to talk about what we, and I'm sure in India as well, I know you refer to as interests in land. Then I'm going to talk about the way in which those interests are created. And then I'm going to talk about the way in which those interests are transferred from one person to another. So to start then with, what are the interests in land? What are the proprietary relationships that a person can have in relation to land in Australia? Well, the first thing that I just want to pause on is to make it clear that you have to have a definition of what land is before you can decide what it is that a person can own in relation to land. So when I'm talking to my students, I always start with what my property professor, way back when I went to law school, the way that he defined land was to say that we start with what you call a giant carrot theory of land for the definition. So if you think about the earth as a globe, and you think about somebody that has the ownership of the surface of the land, that surface is curved slightly. Well, the way that English law and Australian law has defined land is to say, well, whoever has the surface also has all the way above the surface into the heavens. And so it kind of looks like a giant carrot growing out of the land. That's how we define land. And we say that the person who has the surface of the land also has everything that lies below the surface and everything that is in the airspace above the surface. So that's our sort of our working definition of what land is in Anglo-Australian law. Now, we need to add one important point to that definition, and that is to say that we can have personal property, chattels or movables, whatever you want to call them, that can become attached to the land. So someone might have a lot of bricks and lumber and mortar and whatever else it is, and they put those all together to make a house which is attached to the land. And whereas the bricks and the lumber and the mortar were personal property when they started out, once you put them all together and attach them to land, they become, as far as the Australian or the Anglo-Australian law is concerned, they become part of the land. And we call that the law of fixtures. Any personal property that becomes attached to land is treated in Anglo-Australian law, and I'm sure that it is similar in Indian law, it becomes treated as though it is part of the land. So our definition of land then is the surface, everything below the surface, everything above the surface, and anything such as any personal property. And then one last point before I'll move on, then, that is the government in Australia, the surface or on the surface is not owned by the surface holder. That water is owned by the state. Similarly, mines and minerals, coal, iron ore, copper, gold, etc., are not owned by the surface holder, they are owned by the state. And that's done by legislation. So there is significant legislation in every Australian state and territory which defines water as being held by the state and which defines mines and minerals as being held by the state. So that's where we need to start. We start with land. So we've got a definition of land, and now we want to know what can a person have in relation to land as far as property is concerned. And that's where on my outline, I talk about what's called clausus, the numerus clausus, and that is a Latin term. I think it's probably fairly recognizable to people in most legal jurisdictions. It's had a real renaissance over the last few years. There was one time when there was very little scholarship on what the numerus clausus meant. But if you look at American property law, a lot of theorists and scholars in the United States now, they are really starting to develop the concept of the numerus clausus. We don't need to go into all of that. All we need to do is say this much. The numerus clausus is a Latin term which effectively means a numbered class. So there's a closed category of proprietary interests that can exist in relation to land. That's known as the numerus clausus. And the reason for that is there's actually a very good policy reason, because the courts are concerned about allowing proprietary interests in relation to land, or the law is concerned about allowing proprietary interests in relation to land because of the effect that proprietary interests have. If you think about what property is, it is the right of use, it is the right to exclude others, and it is the right to transfer a thing, whatever it happens to be, as the owner or the holder sees fit. So the holder can satisfy their own preferences as to how they're going to dispose of whatever the thing is. So here we're talking about land. So if you are going to say, if a legal system is going to say, well, someone can have the right to use the land, someone can have the right to exclude others from the use of that land, and someone can have the right to decide how that land will be disposed, either to keep it for oneself or to sell it, or lease it, or give it away, lend it to someone else, or whatever it happens to be. That is a very important set of rights. It's what we call the bundle of rights. And the law is reluctant to give that bundle of rights to just anyone, because once it does, then the person that holds those rights has a very powerful tool. They can use whatever it is, they can prevent others from using whatever it is, and so on. So that's a powerful tool that the state always backs property. That's what gives rise to property. And so the law is reluctant to allow just an endless category of proprietary rights in relation to land. So if I was to enter into a review that I'm talking to today and said, okay, we're going to create this new type of property in relation to land. And then we went to a court and said, now court, we want you to enforce that as a type of property. And the court always did that. Well, we would be creating potential rights that would bind other people outside of our transaction. That would become ad infinitum. And then people would never know what their rights were and were not in relation to any given piece of land. So what the law has done over a very long period of time, and in relation to English law, which has been adopted in Australia and Canada and India and so on, the English law over the course of about 1800 years has developed the idea that there is a numerous clauses. There's a numbered class, a closed category. The law will only recognize those proprietary interests in land and no others. So if you look at the history of land law in England and in Australia and Canada and so forth, what you'll find is that it has been probably, 1,000 years since there has legitimately been a new interest that is a proprietary interest that has been identified in relation to land. So we've got a very defined set of proprietary interests that a person can have in relation to land. What is that defined set? I've listed them on the document which I distributed. I'll just tell you what they are very simply. They're what we call the estates. That's an English term, and I'm sure that Indians lawyers will be familiar with that as well. It's a concept that comes from the English law, and it is basically a relationship to land with possessory. In other words, the estates allow someone to have exclusive possession of the land. And then there are some interests which we call subsidiary interests or incorporeal interests. And those are interests that do not allow possession of land. So there are basically three in each of those two categories. In the estates, there's what we call the fee simple estate. The fee simple estate is the largest, the fullest proprietary relationship that a person can have in relation to land in Anglo-Australian law. It gives a person exclusive possession of the land for a perpetual period of time. It does not end. So whoever has a fee simple is said to have that exclusive possession. It goes on without end. So that is when we say that someone is an owner of land in Australia, typically what we mean is that that person has a fee simple title in relation to that land. The second type of estate is what we call a life estate. It is exactly like the fee simple estate, except for the fact that it only lasts for the period of time of a person's life. It can either be for the life of the person who receives the life estate, or it can be for the life of another person, not the person who holds the life estate. But other than that, it is exactly like a fee simple. It is absolute and exclusive possession in relation to land, but now only for a defined period, the life of a person. And the final type of estate is what we call the leasehold estate. And the leasehold estate is, I know, familiar to Indian land law. It is simply the ability to have exclusive possession of land for a defined period of time, and there's usually a rental which is payable along with that defined period of time. So it's exclusive possession for a defined period of time. The fee simple is exclusive possession forever. A life estate is exclusive possession for the life of a particular person, and a leasehold estate is exclusive possession for a defined period of time, but not forever, not ad infinitum. So we typically refer to those as the freehold estates. In other words, it means that if somebody has one of those interests or estates, then they are said to have possession of the land. They've got exclusive possession of the land. And then the second category is what I already referred to as the subsidiary interests. And there are three of those as well. There's what's known as the easement or the right of way. The simplest way to think of that is if I have a piece of land and you have a piece of land, and my piece of land is inaccessible unless the road which adjoins your land, then that ability to cross your land is what we would refer to as an easement. There are certain ways in which an easement can come into existence, but the simple point is it's a non-possessory right. It simply allows me to go back and forth in a certain place over the land of another for certain purposes. It can also be the case in some instances that an easement will be negative. In other words, it allows me to prevent you from doing something on your land in certain circumstances. So it can either be positive, it allows me access across your land, or it can be negative. It allows me to prevent you from doing something on your land. The second subsidiary interest is what we call the mortgage. That will be familiar to everyone. It is simply a security interest. So in other words, someone makes a loan of cash money to another individual. That individual who receives the loan then gives security over land that they have, such that if that person defaults on the repayment of that loan, then I, the lender, would have the ability to seize the land to recover the debt. So that becomes a real property interest, as you know. That obviously operates in Australian law as well. And then the final subsidiary interest, which I won't go into any detail on, is what we can call the rent charge, or there's also what's known as the profit a prawn. I didn't put that on the list. I should have. It's profit, so Profit, and then a with a little apostrophe over the top, prond, Prendre, profit a prawn, it's pronounced. It's a law French term. That basically is the right to go onto the land of another, to take something away from that land, which forms part of the land. So, in other words, an example of that would be where you have land and you've got a particular something that's valuable on your land, such as, let's say, sand or something like that. And you say that I can come onto your land to take away the sand. That's a profit a prawn. Okay, so that can be a proprietary interest as well. So we basically got, as I say, the numerus clausus. There are 3 estates. Those are all of the proprietary interests that a person can have in relation to land. And what we say is that all of those can exist in law, which means that once they are created, if I transfer my land to you, but my land is, let's say, subject to an easement to some third party, then when I transfer it to you, as long as that easement exists in law, then the easement will also bind you. Right? So it binds me. Well, I've got the land. When I transfer it to anyone else, it also binds them. That's a very important point about the existence of proprietary rights in law. The fact that they bind, and this is a legal phrase or a term of art, they bind all the world. So anybody that holds that land will be subject to any proprietary rights that exist in law before they become the holder of that land. Just to reiterate that example, I've got a fee simple title, so I've got absolute ownership of land, but it's subject to an easement in favor of some third party. I transfer my fee simple title to you, then you also will be subject to that easement over your land. So that's the existence of the closed category of proprietary rights in land at law. The only other thing I want to add to that are 2 points. One is there's also the body of law known as equity. I know is also something that is known in Indian law as well. All of those interests that I've just described as falling within the numerus clausus can also exist in equity. The big difference with equity is that although those rights will bind all the world, that will only be the case if the person has notice. So to use my same example, if I have a fee simple title and there is an equitable easement in relation to my fee simple, pay it to you, then you will only be subject to that equitable easement if you have notice of the equitable easement prior to the land being transferred to you. That is a fundamentally important point of the operation of the law of equity in relation to property, that it allows for the binding of all the world provided there is notice. So that's a very important point. Only other point I want to make about equity did in fact allow for the creation of one additional proprietary right that exists only in equity and not in law, and that's what's known as the restrictive covenant. So a restrictive covenant is very similar to an easement, a negative easement, but this is a particular type of negative easement or covenant, a restrictive covenant, which will be enforceable only in equity. We don't need to say too much about that. Typically where these arise is in the development of new, so when you're sort of, it occurs in the context of planning law. So suppose that somebody has a big piece of land, they want to subdivide that land and build a bunch of houses on it. There may be a bunch of restrictive covenants which are created at the time of that subdivision to prevent any one individual landholder from doing anything that may interfere with the use of another landholder. So it's effectively a negative easement that is created in relation to all of the blocks of land in that subdivision, and it's enforceable only in equity. It's not something that we need to worry a lot about today. I'm just mentioning it for the sake of completeness. The final thing that I want to talk about in relation to interests in land is what is referred to as a sui generis, a unique category of interest in land. And in Australia, there is one type of title, land title, that falls within this category of sui generis interests, and that is what we call in Australia native title. Title, I might just say a few words about that because I think that's an important dimension of Australian law. Native title captures the idea that there is a proprietary relationship which the indigenous inhabitants of Australia, the what are known as Aboriginal and Torres Strait Islander peoples of Australia, there is a type of title which is recognized in those indigenous holders who occupied Australia prior to the acquisition of sovereignty by the British Crown. So I'm just going to tell you a little bit of the history about this because I think it's important. The British Crown obviously acquired sovereignty as far as international law was concerned in relation to the Australian continent sometime between 1788 and the early 1800s, about 1810 or 1815. During that period of time, the British Crown progressively acquired sovereignty over the whole continent of Australia. And at the time that that sovereignty was acquired in international law, there were three ways in which new territory could be acquired. There was conquest, right, where there's actually a defeat of a system that already is in control of a particular territory. There's what's known as cession. So again, something similar to conquest in the sense that there is an existing social and legal order in relation to a territory, but that social or legal order cedes some authority in relation to that territory to the state that is acquiring sovereignty. And the third way is the third method of acquisition in international law was known as where land is Terenolius, so land without an owner. There were two ways in which Terenolius could operate at the time that the British Crown was acquiring sovereignty over Australia. One was factual or real Terenolius, which means that the land literally had no one else occupying it. Obviously, we all know that there was nowhere on the face of the planet that was unoccupied at the time of the height of using activities, sort of in the 15th to the 19th centuries. All territory was occupied by peoples during that period of time. So the second category of Terenolius what is known as fictional Terenolius. And what needs to be said about that is it was a highly racist form of acquisition of title or territory or sovereignty over territory that was exercised by European colonizing powers. And so in the case, what that effectively means is that although there might have factually been people in occupation of territory, if those people did not conform to what were considered European standards of occupation, then they were treated as not being there. And as I say, that is a deeply offensive and racist means by which sovereignty was acquired. But it was the means by which sovereignty was acquired in relation to Australia. So although there were indigenous inhabitants of the entirety of the Australian continent at the time that the first sovereignty was acquired in 1788, that was ignored because it was considered by the British Crown that the people that were in occupation were not occupying that land in the way that Europeans would occupy that land. So it was taken from 1788, but never really affirmed directly. There was some case law that referred to the idea in the Privy Council and in the High Court of Australia, but they never really gave a definitive statement that the acquisition of sovereignty had given the absolute ownership of all land to the British Crown for the purposes of creating other estates and interests in the numerous clauses. So it was always just assumed from 1788, for over 200 years, it was assumed that if there had been native title at the time that sovereignty was acquired between 1788 and the early 1800s, that native title had been extinguished by the acquisition of sovereignty until the late 1980s. And finally, in 1992, the High Court of Australia, which by that time was then the final court of appeal, the Privy Council no longer had final appellate authority in Australia. By that time, the High Court finally decided that native title could still exist in relation to Australian land. And the way that the High Court did that is as follows. The High Court said that the acquisition of sovereignty was a political matter that was non-justiciable. In other words, it was impossible for the High Court to say anything about the acquisition of sovereignty. But what the High Court said they could do is consider what are the consequences of the acquisition of sovereignty. And they said that the consequences depend upon what the crown acquired in acquiring sovereignty. So what had always been assumed was that the crown had acquired absolute ownership over the whole of Australia. And the High Court said that, in fact, that was not the case. And the High Court looked at case law from all over what had been the British Empire and found that, looking at all of that case law, that what the crown actually acquired when it acquired sovereignty in Australia was what was known as radical title, not absolute ownership, but radical title. And radical title meant that native title was not extinguished, because radical title is not an ownership interest. Right. It's a power that allows the crown to create ownership interests. So what the High Court said is that when sovereignty was acquired, no native title was extinguished because the crown only acquired radical title. But over time, the crown, in exercising the power under radical title, could extinguish native title. And so what the High Court said is that every time the crown exercised the power of granting a fee simple title to anyone, remember what I said about the fee simple title, it's the largest bundle of rights, it's like absolute ownership. The High Court said that extinguished native title. So what you got was, in the High Court, the extinguishment of native title in a piecemeal way. Every time the crown created a fee simple, that would extinguish a little bit of native title. It's a terrible history. It really is shocking, and it is abhorrent. Unfortunately, we need to face up to it because it still has implications today. So that was a case by the name of Mabo, M-A-B-O, and Queensland. That was the 1992 decision where the High Court says native title still exists. And then what happened after that is the Commonwealth, the federal government, passed a piece of legislation called the Native Title Act, which is a very long act. It's very complicated, but that deals with the establishment of any existing native title going forward. Given that native title has been found to exist, now everything is dealt with under the Native Title Act, which was enacted by the Commonwealth, the federal government, in 1993. So those are the interests in land. Now, what I want to do is I want to move on to creation and transfer of title at general law. So this is sort of really still under the English law, but this existed for at least, between 50 and 100 years following the acquisition of sovereignty in Australia. But what you required, if going back to when I was talking about the numerous clauses, and I talked about the fact that those interests and estates could exist at law, there was a particular way in which you had to create those interests for them to exist in law. And the way in which you created a legal estate or interest, you had to do three things. One, that had to be created by a contract which was in writing. Secondly, the contract itself had to be creating one of the estates or interests that was recognized or is recognized in the numerous clauses. And thirdly, once the contract had been executed, then another highly formalized form of contract known as a deed also had to be executed. So as long as all of that was done, then you would have a legal estate or interest. So if I have a fee simple and I want to sell it to you, then what I would need to do is enter into a contract in writing with you for the purchase and sale of my fee simple title. We would have to obviously make it clear that it was for the fee simple title, and then we would execute a deed by which the title itself would be conveyed from me to you. That's the legal creation. In equity, we find that there are a number of ways in which the numerous clauses, the estates or interests of the numerous clauses, can be created. We can either do that by way of an express trust, or we can do that by what's known as a resulting or a constructive trust. And I won't go into the detail on those other than to say that if those come into existence, then, as I said earlier, they'll be enforceable as equitable interests in relation to land. But the really important means by which equity operates to create an estate or interest is through a case known as Walsh and Lonsdale, which is on my outline. And then there's also what's called the equitable doctrine of part performance. So Walsh and Lonsdale was a case that said if we failed in some way to create a legal estate or interest, so in other words, typically what will happen in this sort of situation is I have a fee simple title. You want to purchase the fee simple title. You and I agree orally, so verbally, that you're going to have the fee simple title. You give me some money, but we never execute the deed, and we never, in the first instance, let's say we write up a contract, but we never execute a deed. What equity does under Walsh and Lonsdale is step in and say, equity will treat that as having created a fee simple title, even though there is no deed. The big difference is that it's only enforceable in equity. In other words, there has to be notice of it so that for others to be bound by that. So it's slightly weaker than the legal fee simple. And you can do the same with any of the other estates or interests in the numerous clauses. Similarly, the second instance arises where you and I, as I said in the first case, we enter into a verbal agreement, but we never reduce it to writing and we never execute a deed. What's known as the equitable doctrine of part performance will say, as long as you and I acted as though we had an agreement for the sale of the fee simple, then equity will treat that as being creating a fee simple. So equity will step in sometimes to do what the parties have failed to do when they're attempting to create a legal title. The difficulty with all of this, I say at the end of this section, is that there is a weakness or a frailty of the general law. What is the weakness or the frailty? Well, one I've already been talking about, and that is the idea of equitable interests, right? We have to be concerned about whether or not somebody has notice. So I may have an equitable interest, and unless I'm able to make it clear to someone else that I've got that equitable interest, it is very possible for me to lose that equitable interest simply when someone sells their interest, usually the fee simple, to someone else. If that person that is the purchaser in that arrangement does not have notice of my equitable interest, that's it. My equitable interest will be extinguished. It's gone. There's nothing I can do about it. So that's an important frailty or weakness that exists at the general law. But the more difficult problem that exists at the general law is that you need, when you're purchasing, so again, using the example that I keep using, if we've got, I'm the vendor, I'm selling my fee simple and I'm selling it to you, you're the purchaser. We've done everything that we need to do. The only problem is, can you be confident that I actually do, in fact, have the legal fee simple title to sell to you, right? You don't know that for sure. The only way that you can know that is by looking at the chain of title deeds. Remember the deed I was talking about? So if I say that I've got the fee simple, I should be able to give you a stack of documents, which are all the deeds, which show that there's been a fee simple title going all the way back to a crown grant and then moving all the way down to me. That's how you'll know that I actually do have the fee simple title to sell to you. Problem is, it's difficult to access all of those title deeds. Some of the deeds may be lost. I may hide some of the deeds because I'm trying to do something fraudulent to eliminate somebody else's interest, right? You can't be confident unless you can look at all of the deeds, and even then you don't even know if you're seeing everything. So that's a real problem. It's a difficulty when you're trying to sort of make more efficient the movement of land, within a particular economy. That becomes pretty problematic. So what you get is you have this guy, Robert Torrens. He was actually from Adelaide here, South Australia. He came up with a system of what's known as title by registration, and that becomes the Torrens title system. It's named after him. And that's what I want to talk about now. This is the final thing I want to talk about to conclude what I'm going to say. Title by registration. So first of all, we need to just stop for a minute. What is title by registration? Well, when I was talking about the general law, I said that the way that you created a legal estate or interest was you had to have a contract in writing, it had to be for one of the numerous clauses, and you had to have a deed. Registration, title by registration says the deed no longer matters. What actually matters in a title by registration system is registration. And so the way that you create a legal estate or interest in any system, which is a title by registration system, is through a system of registration. And that system of registration tends to be something that is established, maintained, and enforced by the state. And that is exactly what happens in South Australia. One of the very first systems of title by registration in the common law world was right here in South Australia in 1858, when the legislation which was created by Robert Torrens was enacted as the Real Property Act. So that was in 1886, not 1858, 1886. So in 1886, that piece of legislation is enacted. It is still in force in South Australia to this day. It has been amended many times, but it is still known as the Real Property Act 1886. So what is important about a title by registration system? So you've got registration, but there are three things that I just want to point out to you that overcome the weaknesses or the frailties of the general law conveyancing system. First, there's what's known as the mirror principle. So in other words, a mirror, reflection. I look in a mirror, right? So there's the mirror principle. And what that is capturing is the idea that what I can do, rather than having to look at a chain of title deeds, I can go to the government registry office. They will show me one document that lists all of the estates or interests that exist in relation to the piece of land that I am looking at. And I can be confident that that is an accurate reflection of the true state of the legal estates or interests in relation to that land. It's the mirror principle, an accurate reflection of the legal state of ownership in relation to that land. I don't need to go and look at a chain of title deeds. Don't need to be worried about whether something is missing. The government says this is the true state of affairs. So that's the mirror principle. The second principle is what's known as the curtain principle. So here's a problem. So the situation is there may be all sorts of estates or interests that exist in relation to a piece of land that may bind me at general law. So remember, I'm talking about all of those equitable interests. There may be various ways in which I may come to have notice, what's known as constructive notice. And if that's the case, I'll be bound by those interests. But what the title by registration system does is it lowers a curtain around my transaction. So once I become registered, then unless it's on title, unless it's listed on that title when I become registered, no other estates or interests will bind me or be of concern to me. So there's what's known as the curtain principle that descends around a transaction once registration occurs. The curtain principle of a title by registration system is what's known as the guarantee principle. The guarantee principle says that if anybody suffers a loss as a result of reliance on the register, which is established and enforced by the state, then there will be compensation available, and that will be paid by the state. So the government backs, guarantees the registration system. So that is the system that came into effect and into force in 1886 in South Australia in, as I said earlier, what's known as the Real Property Act. So that means then, and this is sort of getting to the end now of what I want to talk about, once I register, my title is absolutely what's known as indefeasible. So it cannot be assailed or impeached or challenged by any other person. That is the creation of the legal estate or interest, and the government guarantees that my title is good. So once registration occurs, we have what's known as an indefeasible title. So going back to the same example I've been using all the way through, if I'm the registered proprietor of a fee simple title, and you want to buy that from me, and we enter into a contract, then we execute an instrument of registration. That is then lodged with the registry office. Then it is registered, and there's a date and a time which is given to that, and that's how we decide when you then become the legal fee simple title holder. At that moment of registration, the title passes from me to you. And then all of those points that I've raised about the idea of the mirror, the curtain, and the guarantee all transfer to you. So you become the indefeasible fee simple title holder. That means you have the legal title, the legal fee simple. Then the question arises, well, what about equitable interests? Well, what we've done under the Torrens title system is we have not abolished equitable interests, but we have said that they are non-registrable interests, which is really just another way of saying that equitable interests continue to exist under the Torrens system. So the law continues to operate as far as equity is concerned in exactly the same way that it did prior to the Torrens title system coming into existence. And the final point then is, well, what about those equitable interests? What if somebody has an equitable interest and it's legitimately created and that they've got it for valid and legitimate reasons? Well, we have what's known as the caveat. So someone can lodge a caveat if they have an equitable interest, and then that serves as notice. So if I then want to purchase that fee simple title, I go and ask the government to see what the title looks like. Your caveat will be on the title showing that you have an equitable interest. That means I will be bound by that interest if I become the registered proprietor of that land. So the caveat protects equitable interests. And similarly, we have what are known as exceptions to indefeasibility. And those also protect effectively equitable interests. So in the first instance, we have what are known as express exceptions to indefeasibility. The express exceptions are fraud. So supposing that I enter into negotiations with someone, but they are acting fraudulently, and they become registered as a result of the fraud that they commit, there is an exception to their indefeasibility. So I could have the register put right again. In other words, I could have myself back on the register as the registered proprietor if I'm defrauded by someone that becomes registered. Similarly, all of the equitable interests continue to exist as exceptions, express exceptions to indefeasibility, provided that there are certain requirements met. And typically, there needs to be some kind of notice that someone will have of a prior equitable interest for it to bind them, or there needs to be a caveat which protects that equitable interest. And then finally, there are what are known as in personam, or judicially created exceptions to indefeasibility. So again, these are a lot of various equitable remedies like proprietary estoppel, unconscionability, and constructive trusts, I should say. Those are judicially created equitable exceptions to indefeasibility that operate in Australian and indeed in English and New Zealand and American and Canadian law. Finally, we can have what are known as statutory exceptions to indefeasibility. Statutory exceptions, the best example, which I always give, is there's legislation that exists in every Australian state and territory about controlling weeds, right? Like growing plants, which are considered pests. You need to keep those under control on your land. And there's a piece of legislation in every state and territory that says, if I don't, in fact, keep those under control, then there'll be a lien or a charge placed against my title in the register, and that will pass with the land. So if I pass the fee simple title to someone else, they will still be bound by that lien or that charge on the land. So that's a statutory exception. It's basically overriding legislation. It's legislation that takes precedence to the Real Property Act 1886. The final point to make, and I'll be finished, is point 5 on my document, which I say is putting it all together. And what I mean by that is simply the point that I've been talking about all the way through this talk, which is simply to say that the main reason all of this matters is when you look at the issue of conveyances, because it's on conveyance when someone who may have pre-existing rights becomes concerned about whether or not those pre-existing rights will continue to be enforceable following a conveyance. So if I have a fee simple title and there's a mortgage and an easement and a profit of prawn and maybe even a lease that I've created in relation to that land, and then I convey that land in fee simple title to you, the question that arises for the person that has the leasehold estate and the mortgage and the easement and the profit is, can I still enforce those rights that I have against this new fee simple title holder? That's what brings all of this together. The Torrens title system, you know, a phrase we have is where the rubber hits the road. When the tires hit the road, that's really why Torrens title and all of this that I've been talking about matters. When you get into that conveyance scenario, when you're concerned about whether a right will be enforceable against someone else or not. So that's, and I see that I've taken probably more time than I even thought I would take, but that's everything I've got to say, and I'm happy to take some questions now. Okay.
First question is, what is the succession policy of land?
Right. So so we have a system of inheritance that operates both under will and in intestacy. So there's what's called the Law of Property Act 1936, which deals with a lot of the issues in relation to the conveyance of land under a will. There's also what's known as the Wills Act that operates. I just can't remember exactly what the year is in South Australia, and that creates all of the formalities for the establishment or the creation of a will. So all real property, so all of those interests and estates that I talked about under the numerous clauses. So if you had a fee simple title or a life estate, we'll put to one side. Fee simple title, a leasehold estate, easement, mortgage, profit, rent charge, and if they exist in equity as well, all of those can be left under a person's will in Australian law. If someone died without a will, then we have also intestate succession. Sorry, go ahead.
What happens to hereditary?
Right. So you mean so like in inheritance, right?
Inheritance.
Yeah. So basically all inheritance of land now has to be dealt with either under a will or under a trust, right? So in English law there was the the entail, the fee tail estate, which is where you could establish that land would pass through through a certain family as long as there were certain descendants that existed in relation to that family. That's been abolished in Australian law. All land now passes on either by way of will or on intestacy. So if someone dies without a will, there's intestate succession legislation that provides a whole list of heirs that are yours. So in other words, it would go to all the people that you'd think that your property would go to. So your children, and spouse, and so on. There's a whole list of people if you don't have a will. The ultimate heir in every jurisdiction in Australia is the Crown. Right. So ultimately, if there are no living heirs under that intestate succession legislation, the land would then revert to the Crown. So that's how intestacy operates.
That's great. Now, second, can any non-Australian purchase and acquire land in Australia?
Yes, that's a good question. And in fact, the answer to the question now is yes. There may be certain instances where there's very large purchases which are made, which the Department of Foreign Affairs and Trade. I'm just not exactly sure what the process is, but there may be instances in which very large transactions may need to meet certain requirements. But for if someone is purchasing residential real estate or even small commercial real estate, that is absolutely possible for someone that's a non-Australian to purchase property under those circumstances. Yes.
Although you covered it, but another interesting question has come, that what is the law related to encumbrances?
In which?
Encumbrance.
Encumbrances, right. Yes. Okay. So that's that point. Subsidiary or non-possessory interests. So easements, mortgages. So all of those are dealt with under the Torrens system in the same way that I was discussing the registration of a fee simple. So if you and I enter into a contract for the creation of an easement, let's say, or a mortgage in relation to the land, there is a process whereby we can register that interest, and it is created then as a legal interest. So we can have legal easements. This is a very good point, actually. I should have mentioned this. All of the estates or interests that were available at general law can be created legally by registration under the Torrens title system. So all encumbrances are dealt with that way. Where you really have the problem is the point that I was making at the end of my talk, is with the equitable interests. That's where you've got a problem, because if someone doesn't realize that they have an equitable interest and they don't realize that they need to caveat that interest, it is very easy to lose that encumbrance, that interest, if there's not some further protection taken in relation to it. That really doesn't change much between general law and the Torrens title system. There's still that weakness in relation to equitable interest. But as long as they're created by registration legally, so under law, or at law, I should say, by registration, they will operate in exactly the same way as they did at general law.